We're here with Ohio State University law professor Peter Shane, whose new book, Madison's Nightmare, goes into explorations of executive power, especially unitary theory of presidentialism. Peter, would you mind explaining, is there anything structural in the Constitution that explains why the trend always seems to be towards more executive power rather than less?
Sure. The Constitution was designed on the premise that what would really constrain each branch was the checking and balancing of the other two branches. And so what would lead to a constrained presidency would be a vigilant Congress and vigilant courts. But of course, courts cannot do anything independently to constrain the executive branch. The only time that courts get involved in delimiting the powers of the executive branch would be if there is a dispute with the executive branch that leads somebody who has standing to be able to go to court, raise the question in a legal suit, and have it litigated, up through the court system. That is pretty unusual when it comes to separation of powers disputes. So the courts tend to be a fairly marginal actor in terms of constraining the presidency. Congress, you would think, could do better. After all, the president can't do anything without appropriations, and most of what the president does in domestic affairs, he does entirely because Congress has authorized his power in the form of a statute. However, every member of Congress has a political incentive, of course, to be reelected based upon doing things that appeal to his or her constituents. That may not lead the member of Congress to want to make very hard decisions. So a member of Congress wants to stand up for national security. That member of Congress may say, well, let's defer to the president, because that way I can go home and tell my constituents I've stood up for national security. Meanwhile, it's the president who's left with the decision whether or not to deploy military force. Congress wants to be able to say, we're tough on the environment, so let's set up an environmental protection agency, and then we can say we've done something for the environment. Meanwhile, the actual hard policy making about what to do on the environment winds up being conducted in the executive branch. So I always say that there's a constitutional argument between people who see the executive branch as being this almost autonomous source of presidential power, and those who regard it as being subject to external constraints. But even if the president is subject to these external constraints, unless we can create a political context in which Congress is vigilant in its use of checking and balancing power, the president's going to wind up de facto with having more and more power over time anyway.